Good morning, everyone. I'm Shan Potts, and I'm really excited to be here in this webinar, meeting Brad and meeting John at ProSePro, and all the exciting things they have to share with us today. This webinar is extremely important for our clients, as we all know that we have cases pending at USCIS that have been pending for a long time, and we're going to get some insight on as to what we can do. So I'm excited about this.
So good morning, everybody, or afternoon, wherever you are. My name is Brad Mandamus. I am a lawyer. I am an immigration lawyer, but I kind of came to immigration through a non-traditional route. My first real lawyer job was at the Department of Justice in the Office of Immigration Litigation in Washington, D.C., where it was my job to travel around the country and defend ICE, USCIS, State Department, all of the agencies when they got sued in court. And so I kind of learned immigration through litigation, which is what we're going to talk about, rather than, helping people file applications and file petitions. And so I have a slightly different view and definitely a different kind of specialty from most immigration attorneys like Shan. And, I'm excited to talk to you guys today about how I've worked with John, who he can introduce himself in just a second, to kind of try to provide these litigation tools to folks even without attorneys. John?
Thanks. Thank you, Shan and Brad. Hello, everyone. I am John. I am one of the founders of ProSePro. I am not a lawyer. And so I say that quite frequently when people ask me for legal advice, because I'm not allowed to give it. I'll defer to Shan and Brad on that part. But I have a background in not-for-profit and in technology. And so I kind of put those two together along with background in education and have built ProSePro as a tool to help individuals get their applications processed more quickly. Brad Mandamus is our attorney advisor. So he has his knowledge and his insights are built into the fabric of everything that we do at ProSePro, even though he is not a lawyer for anybody that we work with.
We've been referencing litigation. Most immigration attorneys focus on transactional work or petitions. They help you file, if you're a victim of a crime, get the supplement B for a U visa, put it all together, follow all of the arbitrary and ridiculous rules that USCIS puts you through, and sends it in to get you an approval. And a petition attorney is I do not have that skill set. But it's an incredibly difficult job because the agencies are always changing the rules, delaying things, and their job is to follow every single one of those rules to the T, regardless of whether they're stupid or not, to get you the approval, right? That's the job. Litigation is a little bit different. Litigation, we get to ask, is that a lawful requirement? Is this too long, right? And then the way we try to hold the agencies accountable is by going to federal court. And when I say federal court, I do not mean immigration court, okay? I do not mean anything that's run by USCIS, Department of State, or ICE, right? But this is a Article 3 federal court where the judge got appointed by a president, and they get to be a judge for the rest of their life. And these judges are not stuck in the echo chamber of immigration. So when you tell them the government's taking 5 years to do something that takes 8 minutes, those judges go, that's ridiculous. Whereas immigration attorneys, and this is not faulting anyone, they go, yeah, that's normal. That's the processing times, right? And so federal court is the great equalizer when it comes to this litigation stuff. And that's where the power of ProSePro kind of comes in, because at some point there are cases that the federal government doesn't really defend because they can't. And we think that those cases settle at such a high level that, meaning 95% of them settle, that there's certain steps you've got to get through, certain hurdles to get that case filed. But once you do, and you're successfully in getting it filed, the government's required to answer you in 60 days. And it's not one of these boilerplate responses that you get when you call the hotline or send something in. They have to go find your file, they have to look at it, and they have to respond in court, right? And so they have two choices. Do they want to fight your case and go all the way to the end and dedicate a lot of resources? Or do they just want to tell USCIS, hey, make a decision? That's all they're asking for. Make a decision. It takes you 32 minutes to make a decision. Just do it so we don't have to go to court and I don't have to try to defend you in front of a judge. That's kind of the big picture of why we are suggesting and urging, and really the foundations of ProSePro, to help kind of expand that accountability to people who don't have attorneys, who can do this on their own. So I'll kind of let it go from there. Shan, go ahead.
Yeah, Brad, what you're describing, I experienced that in real time with my clients. We're sitting on a mountain of cases where the delays are just unreasonable. From your perspective, why do you think we experience why these delays? What's causing these delays?
Yeah, it's a great question. I think everyone naturally says, well, they're so busy, right? They get 10,000 applications a month, and there's only so many adjudicators. And, we hear in the news, everyone's getting fired if they work for the federal government, and they immediately think it's a resource issue, right? What's interesting is that's what the government argues. But we have now, used the Freedom of Information Act to get data and to figure out why it takes so long for certain things. And my conclusion, after looking at literally so if we talk about U visas and the BFDs, I have a spreadsheet with 240,000 lines of data, and it's the filing date and the decision date of every BFD they've issued. Okay. And when you do very basic kind of statistical analysis, and when I say analysis, I mean sorting by filing date or sorting by decision date, what we see is there's just no rhyme or reason to their process. There is not a line. The government likes to say, oh, and I think this is a metaphor that is very intuitive. Oh, I'm at the back of the line. I have to wait till I get to the front. It almost seems like it would be harder for them to do it in a different way than that. But the fact is, they do not do them in order at all. A line is not the right metaphor. If you think of it as a pool, right, that's deep and wide, and they reach in and they might find 5 that were filed in the same month, great, but that's arbitrary, right? And you see, I think it was 30% of BFDs have gotten decisions in less than 180 days. And yet 30% have waited more than, I think it was 72 months. And so there's no rhyme or reason to any of this. And so my answer to your question is the system's broken. Right. And it's not a resource issue. It's a bureaucratic morass.
You see this randomness that's happening here. So for a lot of my clients, when you say BFDs, you're referring to bona fide determinations?
Yes, sir. Thank you. Sorry.
Right. Yeah. So a lot of my clients are waiting for this determination so they can get work authorization, and so they can kind of move on along this process. And so are there particular types of petitions that experience more delays than others in your experience?
Yeah, of course. And one of the things that we think about on the litigation side, that again, petition attorneys don't have the luxury because they have a different job, right? Is how long should it take, right? And so for the bona fide determination, it's a good example. I did a ton of, and again, keep in mind, I've been litigating kind of in the U visa space since 2018. So this isn't an overnight revelation, right? It's taken years and hundreds of cases. But we did the research, right? First off, what is the analysis they're doing? Well, for a bona fide determination, they're making sure you signed it. They're making sure there's a supplement B. And then they review your background checks. Okay, so background checks are a part of it. That's going to take some time, right? But because of a deposition I did a couple of years ago of the head of service center operations for all of USCIS, I learned that once you send in the fingerprints, it takes them 48 hours to get the results back. 2 days. 2 days. And so when you think of the bona fide determination, by the time they send you a receipt, that means your application's complete. 2 days after you do your fingerprints, they have everything they need to make a decision. Okay. So that's the very simple process. The other thing we really look at is, what did Congress want, right? Congress created the BFD process in 2008 by adding a sentence to a statute, a law. And if you go back and do a deep dive, what you see is on the floor of Congress, these congressmen got up and said, it is taking too long for victims of crime to stabilize their lives. This is ridiculous. The Vermont Service Center, and this is literally what it says, should make decisions on this in 60 days. 60 days. That's what Congress wanted them to do.
That 60 days is what U visa applicants should be anticipating if things were happening the way they're supposed to.
That's right. And we kind of look at the whole picture, look at the numbers, look at the service center operations, look at how many adjudicators they have. And that's where we came to a bona fide determination we think should be done in 90 days. And that takes into account the congressional stuff. It takes into account the actual analysis. But as you know, Shan, and your clients know, CIS claims it takes, I think it's now 51 months to do that. And so that's kind of where we come from, a different perspective. We don't start at the processing times. We compare those to what our research and what the analyses kind of point to. And so, 51 months is absurd. That's 4 years, more than 4 years for something that should take them 10 minutes. And so that's where we've been pushing, and that's where we've been having a lot of success.
Right. And so this conversation really resonates with our clients and those people who are filing U visas. That BFD that we're referring to is a bona fide determination, which allows you to move forward with your application and get a work authorization, which is the utmost important for our clients, even as they're waiting. Apart from the U visas, are there other petitions that you find it unreasonable, the delays that reoccurring?
Yeah, absolutely. I mean, we see a lot of delays with, again, kind of the other end of the spectrum, EB-5s. So invest $1 million to get a green card. They claim it takes 48 months to do that application. And again, if you go, I won't go into too much detail, but if you go through the whole process and look at what they're doing, maybe the first one should take a long time, but these are in big projects. And so once you've approved one, the rest of them should go incredibly quickly, but they're still taking 4 to 5 years. The other benefits we see a lot of delays on, unfortunately, are renewals for, say, advanced parole, right? You're stuck in the green card backlog. You have a 485 pending or an adjustment of status, and you have to renew your travel authorization, and it takes 14 months, but your travel authorization is only good for 1 year. So you're necessarily going to have a gap, right? And that can be, I mean, I was on the phone yesterday with a man in LA who was crying because his father had just passed away, but he couldn't travel because he was waiting for his advanced parole, right? And it's just heartbreaking. And so yeah, we see a lot of different benefits where they have delays. Now, keep in mind, some of those delays, I think when we do the analysis, are reasonable. So another example would be, say, some of the applications to get involved in the EB-5 program, where you have to look at econometric analyses, you have to have a business plan, you have to look at the conditions of the economy in, maybe 1 or 2 states. And maybe those should take a little longer because they're very sophisticated and only you have to have certain degrees to even be able to review them. But I will say our view is not that there's a black and white line, but let's look at it. And I will say this too. I do think under the law, a 12-month delay for one person might be reasonable if, say, they have work authorization and they're not worried about deportation, whereas a 12-month delay for someone else applying for the same benefit might not be reasonable because, they're in removal proceedings or something like that, right? And the law says that they're supposed to take that into account, but they don't. They refuse to.
Right. In our space, I see mostly the U visas and the family petitions, even family petitions that are non-marriage based, like siblings. And I see this all the time with our clients. And We do inquiries. Sometimes we do congressional inquiries. What's reasonable? What's reasonable? What's not reasonable in the family-based area?
Yeah. So if we're talking about an I-130, the first question is it current, right? In other words, is there a visa immediately available for this person? If there's not, and you're in that visa backlog, well, if you have to wait 8 years for the visa to be available anyway, a 5-year wait might not be unreasonable, right? But if it is current, meaning there's a visa immediately available to you, you're married to a U.S. citizen or something like that, we say 1 year. And there's lots of reasons for that. But as you noted, Shan, how hard can it be to determine if someone's child or someone's brother? Like this is not
The easiest thing you can do.
That's right.
It's the easiest thing you can do. Yeah.
That's right.
So one odd circumstance that I've seen those called in for interviews on I-130s. The interview is being held, and they're anticipating a decision or request for additional evidence, a denial or approval or whatever, but it gets stuck. It gets stuck after the interview. Is the mandamus process, or does that apply in this circumstance where it's just stuck after the interview?
Yeah. So let's talk about that. So let's say you waited a year for your interview. You do your interview, and now you've waited another 6 months. Well, your total wait time's 18 months, but they have done something, right? They did do an interview, and that's great, right? But it's not a situation where you've waited 18 months for nothing. So you do have to keep that in mind, right? If you have an interview, you probably don't want to sue a week later, maybe a few months later. But the question is, in that situation, right? Why are these delays? And when you get into the field offices, right? And I go to my local field office on occasion, the Charleston field office in South Carolina, and those adjudicators move in and out. So let's say they do an interview, and then 2 weeks later they move on to the next job. It happens where that file just gets left in an empty office, right? And so it's not this bureaucratic problem. It's just there's a lot of things going on, and it's just a stupid reason, right? We forgot about it. It's in that office that no one goes into. And a delay case absolutely fixes those, and possibly is the most effective for what I would call just kind of stupid reasons like that. And we can all understand how that goes on in an office. Like, they're not evil for doing that. They're not doing it to hurt you, but it is what it is. And so getting them unstuck for those kinds of reasons, unfortunately, congressional inquiries don't do it anymore. The ombudsman is so overwhelmed, unless, your name has been in the New York Times or something, nothing's going to happen, right? And so the benefit of these delay cases is it requires the government to do something. Right. Under the law. They have to. And so that's the power.
Yeah. Yeah. How does the, for our clients, how does the mandamus process work? Like in very simple layman's terms, how does it work? What are the steps?
Yeah. Great question. So for these cases with ProSePro, you fill out an online questionnaire to give us the data we need. We produce all of the documents you need to file a case in federal court, provide the instructions on how to do it, and the follow-up in the background. And essentially what it is you get a package in the mail, you sign it, send it off to the appropriate places. Once it gets to the U.S. Attorney's Office for wherever you file, those are the government attorneys that defend these. Essentially, they have 2 months to file a response. So during that 2 months is when you see all the settlements, right? And I would say, for my private cases that I represent people, we have like an 85 to 90% settlement rate. Okay. It's much, much higher for pro se applicants in our experience. And that's because during that 60 days, right, the government has to make this choice. Am I going to fight it, or am I going to settle it? And settlement means you get what you want, right? You get a decision. And as a former DOJ attorney, it's incredibly risky, ethically, to talk to someone who doesn't have an attorney, because you can't provide them legal advice, right? You can't explain the system, and heaven forbid they misconstrue something you say as legal advice. Now you're in trouble.
Right.
And so, do I want to fight a case where someone doesn't have an attorney, or do I just want to settle it and get it over with and dismiss the case? And I think
Particularly when it's not reasonable.
that's right, especially when am I
Particularly
really
when it's
going to
not
go in and
reasonable.
argue that 5 years is reasonable. And this is where I think John mentioned that, my role with ProSePro is to be the attorney advisor. I do not represent any, ProSePro customers, but I do write everything and strategize everything.
Right.
And so, and John can tell you, we just revamped our entire complaint for bona fide determinations because we got all this data in. And you got to change it up. If you keep doing the same thing over and over, it's not going to work. And so, I hope that explained. And so if it settles, what that means is the government will reach out, usually by email, and say, hey, we'll get you a decision in 60 days or sometimes 120 days. And you might say, well, that's no good. That's another 4 months. But we have people suing on the 91st day. So that means they're getting work authorization and deferred action through the bona fide determination in a total of about 6 to 7 months, considering they say it takes 4 years,
Right.
way ahead of the game.
Right. We have clients who have been literally waiting for years on some of these petitions. And that's the reason why we thought it was really important to have this conversation today. And when I asked how it worked for our clients, essentially it's kind of, if I start this process, what will happen after 60 or 90 days? I want them to have an understanding, a feel as to what the waiting process is likely in these cases. I think you're on mute.
I think Brad saw that I unmuted because obviously Brad can speak to it, but because Brad doesn't have any direct interaction with somebody once they start with ProSePro, he's really not allowed to.
Sure.
That's where I come in, and so I see everything that's happening behind the scenes, and even in the front scenes. But essentially, we see kind of a 50-50 split. About half of our customers, they follow this process that you see on the screen, where the summons has been served. That's the thing that starts that 60-day timer where Brad said the government, without exception, has to respond. They have to do something. They have to say, we've seen your application and we're making a decision on what we're going to do about it. About 50% of the people don't hear a word from the government until except to get an approval or a request for evidence, or in very rare cases a denial or annoyed or whatever. But the vast majority of those, the vast majority are approvals. I'm talking well over 90%. The other 50% of those people that don't just get their decision within that 60-day time period, I would say well over 95%. So close enough to 100 of the other 50 get a settlement agreement. And where, to Brad's point, they get a document from the government that says, hey, we're still looking at your application. We're not going to be able to finish it within our 60-day required time period, but we do want to settle this lawsuit because we have to take action on it. If you agree to dismiss it, we promise that within this time frame, which depends on the person, we promise within this time frame, we are going to make a decision on your application. And that gives certainty to the person that they know, okay, well, within X number of days, I will have a decision. And so I can plan for, I'm not sitting here waiting in limbo with the uncertainty of, is it going to be another 3 years or is 4 years or maybe tomorrow? They know, okay, it's within 1 month, 2 months, 3 months.
Perfect. And I, everyone, what I'm experiencing a lot through my clients is a lot of anxieties right now in the new administration. And so those clients who have these petitions waiting, and they've been waiting for years in some cases, there's even more angst about getting clarity as to where they stand. It's a the anxiety level is extremely high, and they're looking for just answers, not to be in limbo, just to be heard. Do you anticipate any at this moment? Have there been any policy changes or any indications from this administration that there's going to be any changes in the mandamus process for our clients? any new legislation, or how's the new administration going to affect this process?
Yeah, what I can tell you is the same attorneys who are defending these cases under Biden are still defending them. And the same personnel at USCIS is still making the decisions on whether they settle these cases or not. Um, we've seen no change to date. And I can tell you, I was in a hearing in Vermont related to U visas a couple weeks ago, and the judge asked the government attorney, "Hey, you've been settling all these pro se cases in Vermont. Are you going to keep doing it, or is the administration going to change it?" And the government attorney hemmed and hawed a little bit, but basically said they did not indicate there's been any change.
Right,
And
right.
in Vermont, I mean, they're getting, John can speak to this more, about 100 new cases a month from pro se folks. And so it's a big part of their docket, considering I think Vermont had a total of 120 cases the year before we started, and now they're getting 100 a month of pro se cases. But the judge sees them all settling, and they don't want to get in the way, right?
Right,
And so, to answer your question, we haven't seen a change. Could it happen? Yes, but we've been preparing for that, and the follow-up guidance and follow-up from ProSePro, we're ready for it. Whenever, if it happens, we're ready for it.
Okay, perfect, perfect. How long has ProSePro been around?
We ProSePro really launched it with full force in May of 2023. So just under 2 years. We did a little bit of kind of beta work prior to that, but really launched in full force in May of 2023.
Great, great. Are there any potential risks for clients to pursue a mandamus action? I know people have, anxieties about retaliation or some particular risk. Are there any risks that you've noticed?
Yeah, and I'm gonna ask Brad to speak to this as well. It's we actually have a lot of testimonies. A lot of people go through our process and they're very grateful, and they're like, "Can I tell my story?" Because I didn't believe that this was true, and so I want to tell other people. Like, I feel bad that I didn't believe it. And over again, they're like, "This." The risk, there's a greater risk in not doing anything, and those aren't my words. That's just what I hear over and over again when I talk to people who have done it. They're like, I regret waiting to talk to you because the risk was in not doing anything.
Right, right.
But is there a legal risk or a risk in your application or in something happening in your application? I'm going to let Brad speak to that from the legal perspective, because there are some very nuanced legal foundational core elements to that. So yes, better coming from him than from me.
So I'm going to give the legalist answer and then the practical answer. The short answer is no. It's unlawful to retaliate against someone for simply filing a lawsuit. A lawsuit is protected under the First Amendment. You have the right to petition to courts. And if the government retaliates because you've exercised a constitutional right, regardless of your citizenship status, okay, then they're breaking the law. And for that reason, you just don't see it. Again, when I was at DOJ, I never once had USCIS call me up and go, "They sued me. We're going to deny everything for them," right?
Right.
And if they had, I would have reported it to my supervisor because, again, while we talk about administration to administration, the same people I worked with under Obama worked for Trump and worked for Biden, now work for Trump again. And there's this core of civil servants that just want to do a good job, want to do the right thing, and that's who you're dealing with. And they don't have personal animosity towards you litigating, because if you didn't, they wouldn't have a job.
Right.
The other side of it too is when you litigate and when you sue them, you're not dealing with the person who's eventually going to make the final decision, right? That's an adjudicator who, is very, very low on the hierarchy. When you sue them, it's going to go to the Department of Justice. The Department of Justice is going to talk to that person's boss's boss's boss, it's his attorney, right? And they're going to make decisions on how to handle it. And eventually they're going to say, just tell them to make a decision. And that person who eventually makes the decision may not even know you filed a lawsuit because of the compartmentalization. And so even if they wanted to retaliate, they wouldn't have the knowledge to know to retaliate against you.
Right,
so,
right.
So I think that's why we just don't see it. And again, could I come up with an example in my career where I thought they retaliated? Yes, but that would be one out of 3 or 4,000 cases. So I think it's more the exception that proves the rule than anything.
Right. I think for a lot of my clients, the way I would frame it, and I would appreciate your insight, is there are a lot of these matters that are just stuck and have been stuck for an unreasonable amount of time for years. And that mandamus is just getting the ball rolling, getting us out of this limbo, getting someone to make a decision, yay, nay, or the other, but to get the ball rolling. Would that be your approximation?
That's exactly right. And again, I think you bring up a very, very good point, Shan. When you do a delay case or a mandamus, you're asking for a decision, not a particular decision, right?
Hmm.
We can't demand the court order them to approve. It's up to the agency. And what I would say is when you ask, are there any risks? Um, maybe not a BFD, but there are certain benefits if you have an adjustment of status pending and the underlying basis is a little questionable. Maybe you have a couple of crimes that's like, there are benefits that go along with having an adjustment of status application pending. And
Yes.
maybe you don't want to speed that up.
Hmm.
But for folks who have nothing, like U visa applicants, if they don't have status, there is nothing to lose
Right.
other than time, stress, and money, of course.
Yeah. When you talk stress, our clients who have these petitions pending, a lot of them, they have these petitions particularly because they don't have status and they're seeking status. So the mere fact of not having status and being in limbo is an issue. And so moving towards a solution, moving to get these cases adjudicated is a benefit. And it's more stressful, more worrisome just to be in limbo than to try to get a decision.
That's exactly right. And when I was in the government, I had no appreciation for how evil and how hard that limbo is. Because I think most people immediately don't assume the government's doing wrong. They assume something's wrong with their case or something's wrong with
Hmm.
them. And it's not the case, right? They just are broken. And it breaks my heart when I'm on a phone call with a potential client. They're going, well, maybe it's this, maybe it's that, maybe it's this. And I'm like, you're going to go crazy trying to figure out what reason when there's probably not a reason. Um, and so I agree with you that, and this is what I really like about ProSePro is, again, attorneys have their roles. I think Shan, you do a great job doing the petitions and strategizing and everything, but this is something where the client can do it themselves and take control over that part of their immigration. And we've just seen a lot of people kind of what I would say is surmount that stress and that troublesome by doing this. And when they come out, they not only have their status, but they feel more powerful, more empowered to kind of push back when things are wrong. And it's great to give the client not only the status, but that kind of boost, right? Because
Right,
they are
right,
people, they deserve better, and they're getting it.
right. I really appreciate what you guys are doing. That's why I wanted to make this handshake and make this introduction because I see it in real time, the anxiety of people just being stuck. And so to have this opportunity to move forward and to be proactive, I think it's great. I think it's a great service that you're doing. I imagine some of our attendees today are going to have questions, and if we can pose those questions, I'm sure we can answer those.
Uh, yes, just I am looking. People, please feel free to ask your questions. When you post a question, it has a small button which says post anonymously. So if you want to ask your question anonymously, you can do that. Okay. Tanya says, if I have my deferred action I-765 and I'm waitlisted, should I really rest assured ICE cannot detain me?
So what I would say is, yeah, there's not much more for you to do. Depending on your filing date, one of the things we've learned in litigation is that right now they are likely to issue actual U visas to people who filed before March 30th, 2017. That's likely the date that they will get up to this year, and then the 10,000 will be gone. If you have filed before then, there might be an opportunity for you to use one of these cases to get your actual U visa. But if you're after that, there's not much else you can do. You've got everything. And And that's a good thing.
So someone is asking, how long must my case be delayed before I can file a mandamus action? So, for example, say if it's day 61 since I submitted my application, so can I sign up with ProSePro's mandamus action service?
So good question. And the answer will be it depends largely on the application that you have submitted and are waiting on. And even within that, some of the different factors. So for example, for a U visa, we mentioned the 60 days that Congress thought it should be. We recommend waiting at least 90 days. A judge would probably be a little reticent to say it's 61 days and Congress said 60. So there's kind of a 30-day grace period built into our recommendation of wait 90. On the 91st day, sure, go for it. And we've had a lot of people do that where at the 91st day, they've submitted their lawsuit for this is specific for the bona fide determination and the work authorization that goes alongside that. Now that's for the U visa. Different applications. Brad mentioned earlier, the I-130. Typically, we say about a year for immediate relatives, though. So if you had submitted an I-130 and the visa wasn't current, so if it was an I-130 for a sibling, an adult sibling, the likelihood if you just submitted it now, you would be waiting several years for a visa to become current. So if there's no visas available, suing for the processing of the I-130 would kind of be an unnecessary point. So that's kind of it depends on the application type. And I will say, without getting too far ahead of us, I know on the last slide, we do have actually an eligibility quiz that someone can walk through and answer a few questions about yourself and your application type. And it will tell you, oh, yes, you're eligible for one of the services that ProSePro offers. And so we'll make that link available. I think is it shanpotts.eligibility or shanpotts.prosepro.co, something like that. Well, it'll be on the screen though. But hopefully that answers your question, Carlos. It depends a little bit, but and we're happy to chat with anybody about their specific situation. If the quiz is unclear, you just would rather speak with one of us.
Yes.
Yes, we have another question. So they're asking if the Trump administration changes the mandamus process after they file their mandamus action lawsuit, will the courts adhere to the previous rulings or the current rule, or will they adhere to the current rulings that have been passed?
Yeah, so a short answer to this is the mandamus statute has been in place for 150 years, and then the thing called the Administrative Procedure Act, which is what our lawsuits are actually under, was passed in 1946. Trump can't unilaterally end those laws, and so they may choose to defend cases and fight cases that they otherwise would not have fought or defended. But we just haven't seen that. And, at some point, the administration's love, or at least lip service to efficiency, right, would tend to say they should settle more and more of these delay cases. But what I can tell you is this, is if the Department of Justice starts fighting pro se folks, we're ready to arm you with what you need to respond and win a case against the DOJ attorney. And I would love to see that personally, to see one of my old colleagues get whooped by one of y'all.
Perfect.
I want to tag on to what Brad just said, just because it was so interesting to me to think about it from this framing when Brad first put it to us, which is the time it takes for someone in USCIS to actually handle your application. It's so simple and so straightforward. That's why these cases are so effective. But the amount of time it takes them to actually do what they should have already done is a small fraction of the time it would take for them to fight the lawsuit. And so that's why when the case is in the right and they're like, yes, this was in indeed an unreasonable wait time, they have waited 91 days or more in the case of the U visa, they have their choice. We could fight this lawsuit, which we will lose if they counter us, because on the grounds we should lose this lawsuit, or we could actually just do what we were supposed to do, which is going to take us about 15 minutes. That's the decision they're making, which is the right decision, but that's what they're doing, and that's why to answer to pile on to Brad's response, that was super interesting to me as a layperson.
And I will say,
Okay.
can you appeal a decision if you lose? Sure. But these delay cases don't often make it through an appeal because they do make a decision, right? And that ends the case, even if they fight you. I mean, I have cases where they fight me and then they make a decision. And there's lots of reasons they might not want to do that, but they get rid of the case. And I will note, kind of comically, I got a million emails about this, but there was an attorney arguing a bona fide determination delay case in Vermont. And the judge said to the government attorney, I see you're fighting this case against a group of people who have an attorney, but you keep settling them for people who don't have attorneys. Why is that? And so I think a lot of people are just really intimidated about going up against the federal government without a lawyer, but it's very effective.
Someone has asked, should you tell your lawyer what you're doing if you join ProSePro?
Absolutely. Again, ProSePro, John does this more than I do, but works with a lot of attorneys like Shan around the country who are looking out for the best interest of their clients, right? Shan sees this as a way to help his people in a way that's different and new and hopefully effective. And so we urge people to be open and honest with everyone. Everyone should be on the same page. That said, and again, I know in the U visa space particularly, if you filed 6 years ago and you haven't heard anything, sometimes it's very difficult to get your attorney to actually answer the phone. And in that situation, nothing's required for you to tell them, but we always urge everyone to be on the same page because we're all on the same team, right? You're the hero of the story here going forward, and we're just, the people on the sideline rooting you on. And we want everyone to be there on the same page because I don't like getting calls from angry attorneys saying, you stole my client and you sued and you shouldn't be doing that. And I'm like, look, whoa, take a deep breath. Let's all talk about it. And then it all ends up great. But we would urge you to talk to everyone because again, Shan is interested. It's not an action against him, right? It helps his folks, and it's just another part of the process.
Mm-hmm. And from a very practical standpoint, if your attorney knows that you're doing a lawsuit, they can be prepared for responses that might come from the government. So if there was to be a request for evidence or a notice of intent to deny or something that you do need to follow up with, it's good for that your lawyer to know that something might be coming, and or even an approval, because they filed your original application. Your documents are probably going to your lawyer's office, and so that they know, all right, I should expect some response, something within this next time frame. That's helpful for them to know. It's helpful for you and them. So that's a really practical reason to do that.
Right, and you want to tell your attorney whether or not it's me or anyone else, so that you can get insight into whether or not you should move forward. There may be particular legal issues that you need to be at the forefront of your mind as you make these decisions. So we're all here to help and to share insight as to how you move forward. And at the end of the day, we want to get these cases out of limbo so people can move on with their lives. To have this uncertainty kind of dispelled, and we can just move on. The mandamus process is really asking the government to do what it should do. That's simply. A lot of times what I imagine is that a lot of these cases are just sitting somewhere. They're just sitting somewhere and they're just stuck. And we're just trying to push these cases to a decision. And that's what the process is like. That's what the process is.
So someone has asked, would the judgment go against me if I file a mandamus action?
So we can't guarantee success, right? But let's just assume the worst case scenario. You file one of these, The government moves to dismiss because that's how when they defend a case, that's what they do in every single one. And you lose the motion to dismiss. Okay. And the judge says, nope, this case is gone. What does that actually mean? It means the judge thinks that the amount of time your case has been pending is reasonable. It has nothing to do with the merits of your case, meaning whether you qualify for a bona fide determination, wait list, or U visa. And so it will not lead to a denial of your application. And again, worst case scenario, the judge just says, no, I think 91 days is reasonable, and I'm not going to order the government to do it. And I will say, it's hard, frankly, to get to a decision from a judge on these cases because what John mentioned, CIS has to say, we can get this done in 10 minutes, or we can risk a decision that would hold our feet to the fire in perpetuity. Because if we win one of these and a judge says everything over 4 months is unreasonable, now USCIS is in a world of hurt.
Right.
And, when I was a DOJ attorney, I would regularly say, look, a bad decision here is a bad thing for you. Is this something you really want to risk? Right. And that's what attorneys do in that space. They advise their client to their best interest.
But what I'm hearing from the nature of some of these questions, I want to make sure that listeners understand what this process is. It's about whether or not the wait time is unreasonable. That's the question here. Whether or not the time that I'm waiting is reasonable from the government's point of view or unreasonable. It's not the merits of your case. So would you tend to agree with that assessment?
Absolutely, 100%. And I think what a lot of clients are surprised about is when they get their complaint, there's not a lot of information about them in it. We provide the facts that you need to have in there to succeed on this case, but we don't want to tell the public or the government everything about you. And that goes to the fact, like, we don't need to go to the details of your trauma of being a victim of a crime, because it's not about the merits. It's just about, you've taken 17 months. This should have been done in 3 months. Get in gear and get it done. And Shan, you said it beautifully. This is something the government's required to do. It's just not doing it. And so we're not asking for special treatment. We're just asking for them to do their job.
Right.
Someone asked, can you renew your 10-year green card if you were previously in removal proceedings, but the case was administratively closed by immigration judge when they went to attend the court hearing?
Well, I think that question is on a different topic. I think that question is a question that your attorney can answer if they represented your removal proceedings, or if you have an attorney. But I think that's a slightly different question than cases pending before USCIS. That's my assessment of that question.
Okay, so whoever has posted that question, since you've done it anonymously, I don't know your name, but please do get in touch with us so that we can actually assess your case, and then we will be able to answer you better, actually.
Right.
Yeah. There's another question that they're asking, is there any visa or legal application where I can't use mandamus action?
Yes. There's some, I'll give you an example. There's a form called a 601A. A 601A is for a waiver for someone who gets an immigrant visa, but maybe they entered the country unlawfully. Okay. And they need this waiver. Right now, in 2022, the processing times for these went from like 13 months to 48 months. Okay. Just crazy increases. So the usual suspects went out and sued for delays. And almost every court to rule on it has said, you can't bring a delay case for this. And it gets hyper technical, and I won't go into that. But I mean, I lost a case in a court of appeals that covers Chicago called the Seventh Circuit. And they simply said, look, this is a discretionary thing. Discretion extends to how long they take to make a decision. So you can't come to court and force them to exercise their discretion a particular way. And so the answer to your question, yes, there are certain benefits applications that you can't sue on. The good news about kind of ProSePro is we've already vetted those, and we're not going to try to sell you something that fails on its face. That doesn't help you. That doesn't help us. It doesn't help anyone. And this is also kind of how I work a lot with ProSePro is my private clients. I'm out there pushing and seeing the new cases that need to be brought and what the demand is. And then if it's the right style of case, helping provide it to folks at a much lower price because of without an attorney, and the same effectiveness. And again, it's not for everyone, but it's helped hundreds of people, hundreds of families. Or can I say thousands now, John? Yeah, okay.
That's awesome.
Okay, so we just have 3 minutes left actually. Can we just go to the last slide, and if you guys could just wrap it up?
Yes. Thank you. So I'll say my piece and I'll let Brad and Shan wrap it from there. But as I mentioned before, there's an eligibility quiz with the URL there on the screen. That will, if you're curious, hey, is a mandamus something that I can pursue with ProSePro? This will tell you, this will give you the information you need. Certainly, you can reach out to anybody on the Shan Potts team or from ProSePro. Our website's just prosepro.co. And we can give you more information as well. But that's been a particularly helpful tool for figuring out, oh, is this something that will benefit me? And you can see all the services listed on our website as well. And thank you for your attention today. That's it for me.
Thank you, guys. I appreciate you, all of us meeting here. I know a lot of our clients are going to be excited about learning more, taking the eligibility tests, and all the information you provided, Brad, today was very insightful. I think this is a way and opportunity for our clients and others just to kind of get the ball rolling and to get out of this limbo state. And the eligibility test is something they can explore to see whether or not this is suitable for them. So I'm happy that we've all met here today, and I hope this benefited the people out there listening.
Thank you, Shan, for letting us kind of speak with your clients. And we believe that everyone who has a benefits application should be treated better than they're being treated right now, especially under the current administration. Especially with the U visas. It breaks my heart that these folks are a victim of a crime. They've helped the police by definition, and then they're treated terribly. And this is our way of pushing back and saying, no, I deserve better. And it's working. And you do deserve better. And this is one more tool in the arsenal to ensure that you can make the best decisions for you and your family when it comes to your immigration status. So thank you guys for letting us join you. And that's all I got.
Great.
Okay, then. We'll just wrap it up now. I have sent the URL on the chat for the webinar as well as in the Q&A section. So anyone who's interested, please do fill out. It's a free eligibility test, and then we'll be able to help you according to your case. Thank you so much for joining on a Saturday. Yeah. Have a great day, everyone. Thank you.
Thank you.
Bye-bye.